Welcome back. We're sticking with Justice Onnoghen's issue. The judgment convicting him is the climax of a trial which started about 3 months ago, precisely on the 14th of January 2019. In this next report, we look at the road to this judgment.
It started with a petition written by a civil society group called the Anti-Corruption and Research-Based Data Initiative. The petition, which was dated 7th January 2019, was addressed to the chairman of the Code of Conduct Tribunal and was marked at the tribunal on the 9th of January as received. The petitioners say that the petition was based on alarming facts which indicate that the leader of the country's judicial branch is embroiled in suspected official corruption, financial crimes and breaches of the Code of Conduct Bureau and Tribunal Act. Some of the alarming facts, according to the petitioners, were that Justice Onnoghen made 5 different cash deposits of $10,000 each into one of his bank accounts on a single day in March 2011. On June 7, 2011, he similarly made another 4 cash deposits of $10,000 each, an exercise which he repeated on June 27 and 28, 2011, when he made another set of 5 separate cash deposits of $10,000 each and another 4 separate cash deposits of $10,000 each. Another allegation was that Justice Onnoghen did not comply with the provisional requirement of declaring his assets every 4 years. The group also alleged that Justice Onnoghen's Code of Conduct Bureau forms for 2014 and 2016 were dated and filed on the same day. Both forms were received in December 2016 after he had been sworn in as acting Chief Justice of Nigeria. In the end, the petition alleged that his financial transactions were not justifiable by his lawful remuneration at all material times. On the 10th of January, a day after the tribunal received the petition, these facts had been reduced into a 6-count charge. In the first count, it was alleged that Justice Onnoghen between 8 June 2005 and 14 December 2016, while serving as judicial officer, failed to declare his assets and liabilities within the prescribed 3-month period after being sworn in as a Justice of the Supreme Court. Count 2, 3 and 4 specifically alleged that he omitted to declare his dollar, euro and pound sterling accounts, all in contravention of the Code of Conduct Bureau and Tribunal Act. And in a move never before seen in the history of Nigeria, the arraignment of the Chief Justice of Nigeria was fixed for Monday the 14th of January 2019. Justice Onnoghen did not show up in court for the arraignment. The CCT fixed the next hearing for January the 22nd, and again he failed to show up. 4 days later, on the 26th of January, President Muhammadu Buhari suspended him from office and appointed the next most senior judge, Justice Tanko Ibrahim, as acting CJN. Despite his absence in court, Justice Onnoghen had a response to the petition. He says that he forgot to make a declaration of his assets in 2009 after the expiration of his 2005 declaration. He also says that the need to declare his assets anew after his November 2016 appointment as acting CJN made him to realize this mistake, and so the 2 forms were made on the same day to also cover the period in default. On the foreign-denominated account he failed to declare, Justice Onnoghen simply said he believed the accounts were not open when he made his declaration. Many looked forward to how he would prove this in court, but despite indicating that he would call 3 defense witnesses, Justice Onnoghen only called 1 witness when he eventually opened his defense. His 60-year-old driver, Lawal Busari, who testified as the sole defense witness, told the tribunal how he drove his boss to the CCB office in 2010 to obtain the assets declaration form. The defense said with the testimony, it sought to puncture the prosecution's claim that Justice Onnoghen did not declare his assets from 2005 to 2016. In their submissions before the tribunal, his lawyers said that his response to the petition was not a confessional statement. They quoted Section 3D of the Code of Conduct Bureau Act, which empowers the Bureau to receive complaints about non-compliance and refer same to the tribunal. A section also has a proviso which provides that where the person concerned makes a written admission of breach or non-compliance, no reference shall be made to the tribunal. Justice Onnoghen's lawyers also argued that the CCB Act, which formed the basis of the trial, was significantly in conflict with the Constitution. They then went on to rely on Section 153 and 158 sub 1, which empowers the National Judicial Council to be solely responsible for the discipline of judges. They cited a judgment of the Court of Appeal Lagos, which held in the trial of another judge, Justice Nganjiwa, that the disciplinary decision of the NJC was a condition precedent for moving against a judicial officer. Justice Onnoghen's lawyers concluded that the tribunal lacked the jurisdiction to proceed with the matter.
Their contention is that we have not proved our case. Our own contention is that we have proved our case beyond reasonable doubt, and it's for the tribunal to now make a decision.
The judgment convicting Justice Onnoghen is clearly not the end of the matter.
It was premeditated. Yes. Judgment had been passed before today.
Justice Onnoghen has already filed his notice of appeal, and this is one case that will no doubt go all the way to the Supreme Court.